Good afternoon. Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson. Present. Assemblywoman Bilbray Axelrod. Here. Assemblywoman Brown May. Present. Assemblywoman Considine. Present. Assemblyman DeLong. Present. Assemblywoman Duran. Assemblyman Gurr. Here. Assemblywoman Hanson. Here. Assemblywoman LaRue. Here. Assemblyman Watts. Here. Assemblyman Urick. Here. Chair Cohen.
And I am present. Please mark Assemblywoman Duran present when she arrives. She's finishing up presenting in another committee. Again, welcome. I'm going to dispense with going through all of the rules because I think we all know them pretty well. Just remember to silence your electronic devices. A little lay of the land. We do have a work session. We're going to do a work session. Then we are going to have a bill hearing. And then, just in case anyone wonders, we probably will be back on Friday with another work session. But that hearing will be at call of the chair. So with that, I was hoping we could, Assemblywoman Duran was on last, her final comments on her bill, but I think we can get started. So with that, we'll go into our work session.
Thank you, Chair. For the record, Becky Peratt, Committee Policy Analyst. Senate Bill 180 makes various changes to groundwater boards established by the state engineer for designated groundwater basins. In summary, the bill authorizes a board of county commissioners to request that the state engineer establish a groundwater board, requires the state engineer to appoint 7 members, authorizes a board of county commissioners to appoint a non-voting member, requires the state engineer to consider the written advice and recommendations of the groundwater board, clarifies that a decision of the state engineer to not comply with the views of the groundwater board is not subject to judicial review, and makes various other changes. Senator Goycochea proposed an amendment to add language that a decision of the state engineer to comply with the views of the groundwater board is not subject to judicial review, and that a disagreement between the state engineer and groundwater board is not admissible in any proceeding challenging the state engineer. Assemblymember LaRue Hatch proposed an amendment to limit each groundwater basin to 1 groundwater board. In a basin which includes more than 1 county, authorize the boards of county commissioners to jointly request that the state engineer create a joint groundwater board, or if one board of county commissioners requests the establishment of a groundwater board in a multi-county basin, allow members who reside in the other county to serve on the groundwater board, and to require that members of the groundwater board must live in the designated basin area.
Okay, committee, do we have any questions? Okay, and then I just want to make sure we're clear. So also the opposite is true, that agreeing with if the groundwater board and the and there's agreement that also is not a basis for a lawsuit, right? That can't be used. We're saying that as well. That if the groundwater board is in agreement with the state engineer, that is also not something that can be raised in a lawsuit.
Erin Sturdivant, Legislative Council Bureau. Yes, I think the opposite would be implied in this case.
Okay, thank you. But also, and then just so we're very, very clear, that just because there are facts that are raised by a groundwater board, issues that they address, that doesn't mean that those facts, if they're relevant, can't be used by someone in a lawsuit. They're not automatically off limits just because it's raised by a groundwater board if it's appropriate for a lawsuit.
Erin Sturdivant, Legislative Council Bureau. Correct. The disagreement or agreement with the groundwater board is not admissible, but any facts or evidence underlying those would be admissible.
Okay, thank you for that. All right, so with that, do I have a motion? Okay, I have a motion from Assemblymember Gurr. Do I have a second?
Second.
I have a second from Assemblymember Watts. Do I have any comments?
Just to clarify, sorry, Chair, just clarifying, the motion is to amend do pass, is that correct?
Yes, it's with the amendments that were discussed. Vice Chair, do you have a question?
Yes.
I don't know if it's I know this is policy, and not the finance area. I'm still a little bit concerned about the amount of staff time and everything, but looking at, there's been no fiscal note already, but that's just my only concern is the concerns around staff time and being able to meet with all the individuals. At the same time, that was not really brought up very well, and so I just wanted to put that on the record, though.
Okay, thank you. Do I have any other comments? Okay, seeing none, all those in favor of amend and do pass with the amendments that have been discussed, please say aye. Aye. Okay, all those opposed, nay. Okay, so that passes unanimously of all members present, and I will give that floor statement to Assemblymember Gurr. So with that, we will end our work session, and we will go into hearing for SB 159. SB 159 revises provisions relating to pest control. And then members, again, I know some of you have other committees, including Ways, so certainly if you need to leave, thank you for coming for the work session. Thank you, Senator Hammond. Please go and I guess you're still honorifically Senator Hardy. So senators, please go forward when you're ready.
Yes. He once famously told me that once a senator, always a senator. So, but that's the peacock move right there. I am Senator Scott Hammond, and I thank you, Madam Chair, and members of the committee for allowing us to come in today in what is, I guess, your penultimate meeting, and talk a little bit about this issue of pest control management. I am going to turn over my time to former Senator Warren Hardy to go over the points that we need to make on SB 159. Sorry, that's a typo, yeah. So, Madam Chair, if you don't mind, I'll hand it over.
Thank you, Madam Chair, members of the committee. Warren Hardy, today representing the Nevada Pest Management Association. I want to thank Senator Hammond for bringing this bill forward, and you, Madam Chair, for having a hearing at this late date. This bill, the necessity of this bill came to our attention as an association during the COVID pandemic, when we were having a very difficult time getting pest management applicators or pest control applicators into the field to do their job. It was very early in the pandemic that Governor Sisolak declared pest management an essential industry. But as many industries had, we lost a lot of folks, a lot of people retired, a lot of people moved on, a lot of people quit. We've always known in Nevada that we have a very, very tough test for pest control applicators. We would submit that tough test is very appropriate. But what we have learned through the years is without the hands-on training to be able to pass that test, our failure rate is very high concerning the actual test. So it's something we've grappled with for some time. This bill originally started out as a bill to provide or create a temporary licensure process. Became clear that we really didn't need the full temporary licensure. That was going to cost money that wasn't necessary. So in the Assembly, we revisited that and adopted an amendment that will simply require the Department of Agriculture to promulgate regulations with regard to pest control applicators. Most states have either a provisional license or they have a process like what we're proposing here, where we can now hire an individual for up to 90 days. They can work in the field for up to 90 days prior to taking the exam. We find in most states when that happens, the success rate of passing the test is significantly higher because they've actually done it. They've done the hands-on. I'm a hands-on learner, so I understand that. So what this legislation would do would require the promulgation of regulations that would allow new hires in this industry to be employed in the field for no less than 90 days. In speaking with the Department of Agriculture, they did have some concerns which we completely agreed with. So rather than leaving that to the regulatory process, we actually put it in the legislation. And the restrictions are that an applicator trainee may only apply general use pesticides as directed, general use pesticides under the direct supervision of a licensed applicator in the state. And the bill distinguishes between a direct supervision, and it defines direct supervision as accessible. The trainee has direct access physically, telephonically, or by some other means to an applicator. That is direct supervision. We then go on to say that the trainee may not apply restricted use pesticides unless he or she is under the immediate supervision. And the bill goes on to define immediate supervision as the trainer being physically present while they do the limited use. Then we also took provisions that were requested by the Department of Agriculture that the committee is to consider as they adopt the regulations, that they must comply with all applicable provisions of federal law governing applicators and the application of pesticides and federal laws relating to public safety, that the regulations are consistent with industry best practices related to safety and training. And so those were items that the Department of Agriculture put in the bill, requested that we put in the bill to make sure those things are addressed during the regulatory process. So with that, Madam Chair, I'd be happy to stand for questions.
Thank you, Madam Chair. I just want a clarification, Senator Hardy, where you were talking, you said it would be up to 90 days, but the way that the bill is written as far as training for pest control, it says not less than 90 days. So is there a cap on those days?
Thank you, Madam Chair. Assemblywoman Considine, I misspoke. It is a minimum of 90 days. We felt the minimum was necessary because that's the amount of time that generally, and I should indicate, and I apologize to staff because I told them I was going to do this. I've got Mr. Jeff Burns, I believe is in the audience in Las Vegas. He's the president of our association, actually practices in this field. But he's my phone a friend, but I don't need one in this case. I misspoke. The bill is correct. It's not less than 90 days. So if there's a reason that the Department of Ag and the regulatory process felt that it was 120 days made more sense, we could do that. But we feel a minimum of 90 days.
Mr. Burns, do you want to add anything to the presentation or just wait and testify in support and be present to help in case there are any questions that need help with answering?
Thank you, Madam Chair. I think I'm good there. I think Senator Hardy's doing a great job, but if you have any questions, I am here available.
Okay, thank you for that. I also, I have a question from Assemblymember LaRue Hatch.
Thank you, Chair. So just to clarify, this wasn't my question, but it just popped into my head because of my colleague. There will be a top limit, right? We can't have someone just infinitely falling under this categorization, correct?
Thank you, Madam Chair. To Assemblywoman LaRue Hatch, that's the intent, absolutely, that there is a limit, and that'll be decided in the regulatory process. But it's not the intent to have it go on forever. I'm not aware of anybody that does that, and we certainly wouldn't in our case. Our intent is to get these folks trained so they can receive the full licensure as quickly as possible.
Now, if I could ask my actual question. Okay. So my actual question, I just wanted to have some clarification on general use versus restricted use. So the general use, I'm assuming, has a lower degree of supervision because that's something that pretty much any of us could go access, and it's not as dangerous as the restricted use. Is that correct?
Yes, thank you, Madam Chair. Warren Hardy. That's correct. General use application is what you would traditionally use in your house. That restricted use are much more potentially. Maybe I ought to let Mr. Burns address that so he can give a clearer answer on the difference.
Yes, Madam Chair, it's Jeff Burns here. The EPA is the one that designates that classification. As a product is being, as it goes to that EPA registration process, they will either label it as a restricted use or a general use. But you are correct, and that label is based upon the toxicity level of it and the, complicated also level of applications.
I have a question from Assembly Member Brown May.
Thank you, Madam Chair. Thank you for the presentation. I'm going to go back to the training piece for just a minute. I'm curious to know, is this is an opportunity to engage in a training program for 90 days, but is it mandatory that you have to go through a training program in order to become licensed? Are we mandating that all new people would have to do this 90-day training period?
Thank you, Madam Chair. That's a great question. What is mandatory is that you pass the test. And so it's not mandatory that you do a training per se. We just have learned as an industry best practice that the best way to get these folks in a position where they can pass the test, which I should indicate is one of the toughest in the country. It has as high a failure rate as any place in the country. And we believe part of that is because these individuals aren't having the hands-on experience. So they will have to show that they're qualified before they receive their license to be an individual applicator.
If I could add to that, Senator Scott Hammond, for the record, it really is about training, right? I spend a lot of my time talking about getting students into more internship programs, and that hands-on approach where you're actually able to do something over and over again, so you have familiarity with something, whatever you're doing. And so that's why I got excited when he brought this to me, because I know that I know a lot of folks who are in this industry, and they just couldn't keep anybody on staff because they couldn't, they had a hard time passing the test. You can take the test often, but if you actually allow them to take the test often, but give them some practical experience, day in and day out, you become more familiar with it, become safer, become better at what you're doing, and then you're able to pass the test a little bit quicker. And so that's the whole intent of it. But what Senator Hardy said is correct. The thing that's mandatory is passing that test.
Thank you, Senators. I sincerely appreciate that. That would lead into the next question being, where are we with regard to workforce development for this particular line of business, and how do we encourage that in some of our trade schools in order to be able to do that? So I appreciate your efforts relative to this piece.
Would you like me to address that? I'm sorry. No? We have, Warren Hardy for the record, we have no shortage of individuals that want to get in this field. It's a well-paying field. It's a good career. We contemplated a full-blown apprenticeship program, but really this is one of those things that just requires on-the-job training. So that's why we opted for this. So thanks.
Okay, I have another question from Assembly Member LaRue Hatch.
I swear I did not walk in with this many questions, but you did just mention students, and I am a teacher, and that always perks my ears. So what are the age restrictions that are associated with restricted use pesticides? Because are we going to see 16 or 17-year-olds doing an internship and then dealing with these chemicals?
Thank you, Madam Chair. Another great question. I need to do my phone a friend with Mr. Burns on that one.
Thank you for the question, Jeff Burns, for the record. There is, as far as the Department of Agriculture is the one that sets the regulations, there are no age limits that they have in place, but where the age limits come into place is set by the insurance companies that each pest control company must have and prove to the Department of Agriculture that you are properly insured to be able to apply pesticides, and those insurance companies set those age limits of what age we can hire at, and that is normally 21.
I'm glad you raised insurance, Mr. Burns, because that was one of my questions. In Section 1, Sub B, there is reference to the business being liable. So I did want to know about the insurance and what type of insurance is required for licensure, that type of thing.
Thank you, Madam Chair, and I'll let Mr. Burns add to that, but I will tell you that we felt very strongly about that being a provision. That was a provision we requested, that the owner of the company and the trainer be liable and responsible for the actions of that individual that will fall under our insurance, but there are stringent requirements on insurance, and I'll allow if it pleases the chair, Mr. Burns, to add to that.
Jeff Burns for the record, thank you. As far as off the top of my head, I don't remember exactly the insurance levels that we carry. But yes, the liability does currently and will continue to fall upon the company itself. Right now, even though once an applicator passes these tests that we're referencing, if there's any improper application, that liability goes to the principal of that pest control company. It doesn't go to the applicator, it goes to that principal. That principal must demonstrate that they know all the laws, that they can, to be able to hire applicants underneath them, and they carry the liability, and they must prove that insurance as well.
Okay, but just to be clear, the insurance is required for the licensure for the primary.
Yes, it is. So each company, every year, we must show that we carry that license. We must renew our license with the Department of Agriculture every year and show that insurance.
Great, thank you. And then, so my next question is about the direct supervision portion. I understand that they're dealing with different types of pesticides, and that there can be availability by phone, that type of things. But I was somewhat concerned because you can have, these are small, for the most part, small businesses. You can be in areas of the state where it's hard to have connectivity, even by phone. And so, I mean, is that something where the regs are gonna handle, just making sure that there's an ability for contact and making sure that when we're expecting that for all intents and purposes, an intern to be able to get a trainee, I should use the proper term, a trainee to be able to get a hold of the experienced person, that they will definitely be able to get a hold of them?
Thank you, Madam Chairwoman. Another great question. Now, the intent of the legislation, and I think it will carry over to the regulatory process, is if there's a circumstance like you described where they're out of range, we wouldn't be able to employ the trainee in that situation. They have to be under the direct supervision, which means they have to be able to reach them telephonically, by radio, and if that's not the case, then they would have to have immediate supervision. They couldn't be out in a situation like that, and that will be incumbent upon us, and I think we plan to make that very clear in the regulation.
Okay, and even if it's a small business and the primary is talking to a client and, the client doesn't want to be interrupted, they're still gonna have to take that call, gonna have to take that radio call.
Madam Chair, that's the intent. We understand that's a little bit of a burden on these folks, but, this is something that we take very seriously, which is why we specifically included the liability provision in there, because this is serious business, and we need to make sure these folks are trained properly, so that would be our intent.
Okay, thank you. So I don't see any other questions, so we will go on to support let's go to Carson City, sorry. Go ahead, Mr. Walker.
Good afternoon, Chair Cohen and committee members. For the record, Steve Walker, former restricted pesticide applicator licensee, passed the test in Ely, Nevada in 1976. I'm here representing Eureka County, and we completely support this bill. Thank you.
Okay, seeing no one else in Carson City, do we have anyone else in Las Vegas? Mr. Burns, did you want to add anything? You're welcome to if you'd like to.
Thank you, Madam Chairwoman. Yes, I would like to just reiterate that at the end of the day, we're trying to, this is a great paying opportunity for people that aren't college bound, and this barrier to entry has really prevented us from putting these people to work. Great people that could do a great job doing it. And so, with this bill, we think that that'll open it. We're not reinventing the wheel. Arizona just was at 90 days. They just upped theirs to 120 to give them even more time. So this is a very common thing. Most states do have it. And Florida actually never, the applicator never has to test. So we're not trying to reinvent the wheel. What we're trying to do is just get these people to work because they're great people that deserve great jobs. So thank you for your time.
Thank you. And I don't think there's anyone else in Las Vegas, but, yep, no one else in Las Vegas. And not seeing anyone in Elko. BPS, if we can go to the phones, please.
Chair, the line is open and working, but there are no callers choosing to provide support testimony at this time.
Okay, thank you, BPS. With that, we will go to opposition in Carson City. Seeing none and seeing no one else in Las Vegas or Elko for opposition. BPS, if we can go to the phones for opposition.
Chair, there are no callers choosing to provide opposition testimony at this time.
Okay, and then we'll go to neutral, if there's anyone in neutral in Carson City. Seeing none. Anyone for neutral in Las Vegas? Seeing none, seeing no one in Elko. BPS, if we can go to the phones.
Chair, there are no callers choosing to provide neutral testimony at this time.
Thank you. Senators, any closing remarks? Okay, we're getting the wave off. Okay, so with that, I will conclude the hearing on SB 159 and open the hearing for public comment. Do we have anyone for public comment in Carson City? Seeing none. Anyone for public comment in Elko or Las Vegas? Seeing none. BPS, if we can go to the phone.
Chair, there are no callers choosing to provide public comment at this time.
Okay, thank you, BPS. All right, so with that, again, we can't expect a work session on Friday, probably call the chair, but just keep an eye out. So with that, we are adjourned. Thank you.